Got some breaking news. The Supreme Court just handed down a new ruling, so I want to bring back in CBS News legal contributor Rebecca Roiphe. All right, so what do we know about this ruling on the Mullen versus El Otro Lado case?
So this is an immigration case. It has to do with the Immigration and Nationality Act. So it's essentially a statutory interpretation case where the Supreme Court is looking at the language of this case, and it says that somebody has not arrived in the United States until they cross the border, meaning that people who are on the Mexico side of the border have not arrived in the United States, which means that they are not entitled to apply for asylum.
And so how did the court rule?
So the court ruled that you have not arrived in the United States unless you are on United States soil, so that those people who are on the Mexico side of the border do not have a right to apply to asylum. So essentially what they have done is uphold this policy. I think it's called a metering policy that essentially allows the United States to control the number of people who actually cross over the border, which then reduces the number of asylum claims that they have to process, because now they still, after the Supreme Court ruling, they do not have to process asylum claims by people who have not entered the country.
Okay. Stay there with us for a second. I want to bring in CBS News immigration correspondent Camilo Montoya-Galvez. So this ruling, what are the widespread implications of this? I know you have covered the sort of immigration developments very closely.
Yeah, and we have to underscore that this policy, the metering policy that restricted the processing of asylum seekers at official ports of entry along the U.S.-Mexico border, actually started at the tail end of the Obama administration and then was expanded by the first Trump administration in 2016 and then 2017. And the stated rationale at the time from the U.S. government was that too many people were trying to request asylum at official border crossings along the border with Mexico. And because of that, the U.S. needed to limit and also basically scale down the processing of people who wanted to seek humanitarian protection in the U.S. And thus, the U.S. government took the position that if the people who were intending to seek asylum did not actually set foot on American soil, but were actually waiting on the Mexican side of the port of entry before being inspected by a U.S. Customs and Border Protection agent, that person was not entitled to be screened for asylum. And now, through this decision, the High Court has sided with the U.S. government in that position that, again, was taken not only by the Trump administration, but also a Democratic administration in the Obama administration. And so for the time being, U.S. Customs and Border Protection agents will continue to be able to continue this metering policy and limit who can actually request asylum. The requirement will now be that people actually have to set foot on American soil before being entitled to be screened for humanitarian protection.
All right, Camilo, thanks very much for breaking that down for us. And Rebecca, there are some other cases that have also been decided this morning.
Right. So there's an important gun control case that's coming out of Hawaii. Hawaii had a law that essentially banned people who had a legal license to concealed carry from carrying guns onto private property unless those property owners opted in, essentially said, we want these gun carriers on our private property. The Supreme Court has struck that down, essentially following a line of cases that have strongly protected gun carriers. And it has said that there is no historical precedent for this law, and because of that, it is presumptively unconstitutional under the Second Amendment.
So for folks watching at home, you mean if a private entity or private property owner says, I don't want somebody with a gun on my property, they're technically allowed to carry a concealed weapon onto their property? You know,
your look of confusion, I think, is a good one, because this is an interesting case, because there is actually an intersection between two rights, as you note, the right to private property and the right to gun ownership. Right. And so I'm trying to, obviously these are very long opinions, so I'm trying to read through it, but essentially you're right that the court has weighed on the side of the Second Amendment over these private property rights. Now, when you think about it, there are also kind of public accommodations laws that say, when you have certain kinds of restaurants or you have certain kinds of schools, businesses, you're not allowed to, for instance, discriminate. And so I think that there's something akin to that here, which is if you're welcoming people into your private property, like a store or a restaurant, that you can't then trample on those people's constitutional rights. And because the Supreme Court has afforded such great protection to gun ownership and gun possession, they have essentially sided with that constitutional right, saying that what Hawaii did that was wrong was essentially say you have to opt in. You have to have a sign on your door saying, yes, concealed carry gun owners, come on in. And that is unconstitutional under this, after the Supreme Court ruling.
Okay.
Were there any others? I know we were waiting for one on a weed killer, I think.
I have.
Everybody's refreshing skills.
Okay, I know. This is what we do in live breaking news. You refresh,
and then try to read, these 100-page opinions. So
here's a different question for you.
Yeah.
Were either of the rulings that we got surprising?
I think not. I mean, okay. I think not. Both in terms, they both were broke down on ideological lines. So they were 6-3 opinions with the 6 conservative justices ruling with the majority and 3 liberal justices issuing dissents. And so I think that's expected in these cases. We have seen departures from ideological lines in important cases in the past this term. For instance, most prominently, the tariff case, where it didn't come out in the president's favor, and it certainly didn't come out, exactly on ideological lines. But in many of these high-profile, controversial cases, we're seeing it break down that particular way.
All right, Rebecca, thank you very much as always.
Actually, we're just going to stay on because we
Have
did
you
just
seen
get
there's a new one, Rebecca?
Yeah,
because we
so
haven't seen it.
It's Mullen versus Doe. So this is the TPS case, and we're going to go to Camilo on this. Camilo, can you come back in? So Mullen versus Doe. Camilo, are you there?
Yes, Kelly. Sorry, I'm still reading that decision.
No,
but this
of course.
case
I'm putting you on the spot in breaking news.
Sure.
Do not worry. So at the heart of this, this was about the Department of Homeland Security had moved to rescind temporary legal protections for people from more than a dozen countries, including Syria and Haiti. So that was sort of at the heart of this. This is what was being challenged, is my understanding. Do you have a sense of how they ruled yet?
I am trying to decipher that as we speak, but as you underscored, the Trump administration had been barred from ending these temporary protections for hundreds of thousands of immigrants from Syria, Haiti, on the basis of legal challenges that argued that those decisions were partially based on racial animus. And so now the High Court has issued a ruling on that, and I am trying to determine what the High Court actually ruled on. And they're saying here that the challenge on the equal protection claim, based on the challenges that have prevented the administration so far from ending TPS for Syria and Haiti, are unlikely to succeed, quote unquote, because a race-neutral explanation for the government's actions exists. So the High Court is saying that the administration has a different justification and explanation for ending these programs beyond that allegation of racial animus. So it does seem that the High Court is giving the administration a lot of deference here to end these programs that, again, have allowed people from Haiti, Syria, but different countries around the globe that have experienced armed conflict or political tumult or any other crisis from being able to go back to their home country. So it's a win for the administration, it seems, that will allow not just the administration to end TPS for Syrians and Haitians, but also potentially other countries currently covered under that humanitarian program. Kelly and Vlad.
All right, Camilo, excellent job doing that in real time for us. Appreciate it. Stay there with us. I want to bring in Rebecca again. Okay, so Camilo just did an excellent job while I put him on the spot reading through everything. Talk to us about what this ruling means.
So temporary protected status is essentially a situation in which a particular group of people can claim that their home country has become so uninhabitable or so dangerous that they are not necessarily entitled to asylum, but they're entitled to this kind of interim status that allows them to stay and work here legally. And what this challenge, the argument was, as far as we're now being able to decipher from the opinion, opinion was that these holders, can claim this status as a protected status, and that the administration doesn't necessarily have the right to say, okay, no longer from this country or this country. And essentially what the opinion is saying is deference to the administration. They can determine who is entitled to this protected status and who isn't.
And so play that out. What are the impacts then in terms, because if the administration then has more of a broad purview, let's say, of determining who can and can't have this, now what does that leave the administration open to be able to do?
Well, I mean, at least in this particular case, there are so many people here due to these humanitarian catastrophes and problems in these countries, particularly Syria and Haiti, that now can be deported. Because if they are stripped of this status, they no longer are here legally, and they can be deported to their home countries. And so the human toll is significant, just because there are so many people who relied on this. And if the administration can, give and take away this status, then they can determine who's entitled to it and who isn't.
We're going to go to Jan Crawford in a second, but I just want to ask you, was this surprising for you, this ruling?
I think not again. I think that there are, certain ways in which this court has pushed back on the administration and other ways in which they've been fairly deferential. And certainly in immigration matters, that's one of the areas in which they've been fairly deferential. So I'm not surprised about this or the prior ruling about, what counts as being on American soil. Both of those cases have to do with the executive power. I mean, they are interpreting it in different contexts, but giving the administration a lot of power to execute its immigration policy.
And to your point, something that I've heard you say before, a lot of these cases are really about executive power.
Right.
All right. Let's go to Jan Crawford, our CBS News chief legal correspondent, who's with us now. I know that you have been pouring through all of these, I am sure. So let's start with Mullen versus Doe. What's your take on this?
Well, obviously, I've just been hearing part of your conversation. This would give the Trump administration the ability to, at least for now, like it's done with Venezuela, potentially rescind this protective status to people from Syria and Haiti. But the court, this is not a majority opinion for all of the different legal arguments. So the court is saying it doesn't really have the authority to review how the administration went about ending these programs or this designated status, but it's preserving constitutional claims. So that's something that, again, we have a pretty complicated decision that we need to get through, but there was not a majority for that part of the opinion. So again, we'll go through more of that. The other cases today are more straightforward, I think. The Monsanto case is a huge win. I guess you guys, I don't know if you've already talked about all of these. That's a huge win for Monsanto and its parent company, Bayer. Last year alone, they faced $1.3 billion in claims from people who said that Roundup and its chief ingredient, glyphosate, caused their cancers. So today, the court is saying that those claims in state courts are preempted because the EPA, over 6 different administrations going back decades, has said that glyphosate is unlikely to cause cancer in humans and is not required any kind of warning label on Monsanto's Roundup products. So again, a very big win for Monsanto, and that's going to cause a lot of that litigation now to just come to a grinding halt. Justice Alito having those 3 other opinions, the 2 kind of immigration-focused opinions. Happy to talk about those too. Again, I'm just joining the show, so you tell me what you want to talk about.
Well, Jan, let me ask you a question about that TPS decision, only because I think what was being argued here is how difficult it is under the court's equal protection precedents to prove that what is an otherwise lawful executive action becomes unconstitutional because of the decision makers.
That's right, Vlad. And what I'm saying is we need to hold off on that conversation because Justice Alito, and this is going to require some study of this opinion. In the outset, we can kind of talk about what it means at the outset, but for the next legal challenges, it's going to require a little more analysis because Justice Alito's opinion for the court wasn't unanimous in all of its aspects, including part of that constitutional issue that was being raised. So
yeah, whether or
I
not
think
they can make a decision,
we need to
because
study this one a little more before we kind of start talking about what it means beyond kind of the immediate. Again, remember, the court refused to block in the interim its efforts to end temporary protected status to Venezuela. So it appears that they're kind of now treating Haiti and Syria the same way. But again, you'll have to get back with me in the next hour once I've had a chance to really read and parse through. And when you get these opinions, why sometimes you can't just immediately say what the holding is because, let me tell you, Alito announced the judgment of the court and delivered the opinion of the court, which means there is a majority opinion, except as to Part 3A. So that tells you that there's not a majority for Part 3A of this opinion. So then you got to go through and see what is Part 3A. That's the constitutional part.
Okay, so stand by.
So we'll talk about that one our next hour.
Yeah, for sure. We won't be here, but that's good. Let's bring in Camilo real quick. You had some thoughts, Camilo.
Yeah, Vlad, so I would concur with Jan that we need more time to analyze the legal implications of the ruling for other TPS programs. But what I would say about the underpinning legal argument to the challenges against the terminations of TPS is that was based on the claim that President Trump and then Secretary of Homeland Security Kristi Noem were motivated, at least in part, by racial animus and xenophobic statements in their decisions to end TPS for Haiti, Syria, and other countries around the globe. But the court is saying here quite clearly, and I quote, that none of the cited statements by either the president or the secretary was overtly racial, and in substance, all expressed policy views that could rest on race-neutral justification. So, in other words, the High Court is saying, colloquially, that there were other justifications and reasonings for why the Department of Homeland Security ended these temporary humanitarian programs. We should also underscore that DHS has long argued under this administration that TPS has been abused by Democratic administrations, that it has been extended for far too long despite improving conditions in certain countries, and that the policy itself attracts illegal immigration. The court seems to be saying that those justifications can clear the way for DHS to end these programs, even if there are concerns that some of the comments made by President Trump and Secretary Noem were at the very least insensitive, but in the words of advocates, racially motivated.
All right, Camilo, Jan Crawford for us in Washington, Rebecca here in New York. We thank you both. I guess as we still try to understand and digest these decisions from the Supreme Court, what we can say with some degree of certainty is that the High Court has decided with the Trump administration on these two very big immigration cases. I mean, we're still trying to figure out the mechanics of the decisions and how they split them, how they were split up in terms of who sided with the government, who sided with the plaintiffs. But the bottom line is the president is probably going to be on Truth Social very soon, crowing about these two very big wins.